The foundational premise of civil law is autonomy. When two parties agree to terms, their contract becomes the binding law between them. But that autonomy has a strict limit. When an agreement crosses certain legal or moral boundaries, the state steps in and completely annihilates it. This mechanism is Article 1409 of the Civil Code. It dictates that any contract contrary to law, morals, good customs, public order, or public policy is void and inexistent from the very beginning. These contracts carry two defining characteristics. The first is incurability. You cannot fix them, you cannot ratify them later, and the mere passage of time will not make them valid. The second is immutability. The right to defend yourself against an illegal contract by pointing out its illegality can never be waived by either party. Unlike a voidable contract, which remains valid until a court officially annuls it, an Article 1409 agreement is a legal phantom. Regardless of what the parties originally intended, the justice system treats the transaction as if it never happened at all. The law identifies 7 specific scenarios that trigger this absolute nullity. We can group these 7 categories into 2 distinct buckets to understand how they actually work in practice. The first bucket contains what the law calls inexistent contracts. An inexistent contract completely lacks one or more of the essential elements required to form an agreement: consent, object, or cause. This includes conveyances based on forged documents, or transactions that are absolutely simulated and fictitious. The second bucket contains void contracts. Unlike inexistent agreements, void contracts possess all the physical elements on paper. The parties consented, there is an object, and there is a cause. The state strikes them down because that object or cause is actively illegal or expressly prohibited. For example, Article 1491 strictly prohibits lawyers from purchasing property that is currently the subject of litigation they are actively handling. Whether a contract is inexistent because it is missing crucial pieces, or void because those pieces are poisoned by illegality, the legal outcome is identical: absolute nullification. To see how courts police the boundary between contractual autonomy and public policy, we have to look at how this applies to financial forbearance. When analyzing loans and interest rates, courts must factor in Central Bank Circular No. 905. This circular effectively suspended the interest ceilings prescribed under the usury law. On paper, this gives parties wide latitude to agree on practically any interest rate they choose. However, the Supreme Court continuously intervenes. If a stipulated interest rate is deemed excessive, iniquitous, or unconscionable, routinely striking down rates of 36 to 66% per annum, the court declares that stipulation void ab initio for being contrary to morals. This chart visualizes the exact mathematical reality of the Abella case, starting with an initial loan of 500,000 pesos. The parties in this case agreed to an interest rate of 2.5% per month, which compounds to 30% annually. By the end of the 9th year, the outstanding debt had multiplied more than tenfold. By 2015, the obligation had multiplied by more than 66 times, pushing the total owed to over 33 million pesos. The court ruled that imposing a rate that bloats a 500,000 peso loan into a 33 million peso unpayable debt is repugnant spoliation. It functions as unjust enrichment at the expense of the debtor, rendering the interest stipulation completely void. The law respects the ability of adults to set their own terms, but mathematics that effectively enslave a borrower trigger the state's moral veto.
Autonomy has a hard, numerical ceiling. This creates a critical legal question. If the 30% interest rate is void from the beginning, does the borrower get to walk away from the original 500,000 peso loan entirely? They do not. The courts applied the doctrine of severability. Voiding an accessory stipulation, like the interest rate, does not automatically destroy the principal obligation to repay the borrowed money. Looking back at our chart, the court treats the unconscionable interest rate as if it were never written. It is legally erased from the document, but the debtor cannot borrow money for free. To prevent unjust enrichment on the borrower's side, the court substitutes the voided rate with a presumptive reasonable compensation. That compensation is the statutory legal interest rate, historically set at 12% per annum and reduced to 6% per annum after 2013, creating a modest, flat line of accumulated interest. In this context, Article 1409 is not a blunt instrument used to destroy entire agreements. It is a scalpel, excising the illegal overreach while preserving the foundational duty to repay what was owed. We see a different application of this principle when we examine the power dynamics of employment law, specifically regarding labor quitclaims. As a general rule, the law looks with disfavor upon quitclaims and waivers signed by employees. These documents are routinely scrutinized because they are often secured through pressure by unscrupulous employers evading their legal responsibilities. However, cases like Goodrich Manufacturing establish an important nuance. Not all waivers are automatically void against public policy. The court applies a specific test. A waiver will be struck down if there is clear proof that it was wangled from an unsuspecting or gullible person, or if the terms of the settlement are unconscionable on their face. Conversely, if an employee is highly educated, fully understands the document they are signing, and the settlement offered is reasonable, the contract is completely valid and binding. Employees will often cite dire necessity to invalidate a quitclaim, arguing they only signed because they desperately needed the money. The courts consistently rule that financial urgency alone is not enough to annul a release, unless there is proof the employee was actually tricked or forced into accepting an outrageously low amount. In labor disputes, Article 1409 functions as a shield against exploitation. It requires courts to evaluate the actual power dynamic and the fairness of the consideration, operating on the premise that consent is invalid if it is engineered solely through desperation. This brings us back to the core operational reality of Article 1409. When a contract violates these boundaries, the defect is absolute. Because of the doctrine of incurability, no amount of subsequent actions, side agreements, or behavioral shifts by the parties can cure or ratify the infirmity. Even if the parties execute partial or full performance of their obligations under the void agreement, those actions produce no legal effects whatsoever. The Supreme Court summarized this definitively in Development Bank of the Philippines versus Court of Appeals. A contract denounced as void is necessarily no contract whatever. Because the act is inexistent in the eyes of the law, the parties and the subject matter remain exactly as they did before any agreement was attempted. Article 1409 exists as the state's ultimate fail-safe. It ensures that the machinery of contract law can never be weaponized to legitimize exploitation, permanently protecting the foundational morals and public policy of the jurisdiction.